Okay, so it's 10 o'clock. We're going to get started. Welcome to this week's webinar. We've got a special guest, Andy Ives. Andy is a certified financial planner and a credit investment fiduciary. We're going to talk about trusts and IRAs today. This is another complex topic that has been made more complex by legislation changes. Andy's an IRA analyst with Ed Slott's Elite IRA Advisor Group. He's got 25 years experience in the business. He's, as I said, a certified financial planner. And Andy's one of my go-to people on the group. So he's often hearing from me when we have questions about our clients or plans we're working on or very specific issues. And we were chatting earlier. We have a great webinar from a couple of years ago now discussing net unrealized appreciation, or NUA, that I've heard really great things about from folks. So if you'd like to go back and listen to that, you certainly can. So before we start talking about trusts and IRAs, I want to talk about some upcoming events that we have. So we've got classes starting next week, January 30th and February 6th, so 2 Thursdays, and 2 Tuesdays, February 4th and February 11th at Rider University in New Jersey. Both of those classes are absolutely full. We've actually got about a 30-person waiting list for those classes. So thank you. If you have an interest in attending these types of classes, the Changing World of Retirement Planning or other retirement planning classes, reach out to me and let me know, and I'll make sure you get the invitation. We are Attleboro Wealth Management is the sponsor of a wine walk that's scheduled for May 17th, and it's part of the Newtown Theater. For those of you who are clients, certainly, or who've been listening, I'm on the board of the Newtown Theater here in Newtown. It's the longest running theater in the nation, and it's a really cool place. And we've had some great events there. We had Ed there, I guess, a year. Was it last year? Ed and Dave McKnight, Andy, came out and
Okay.
spoke, and they did a great job. We're also sponsoring something called Hope on the Vine for our local Rotary Club. And then we have a movie event at the Newtown Theater. It's called The Psychology of Retirement, and it's written by the movie is written and directed by the best-selling author of The Psychology of Money, Morgan Housel. So that should be a lot of fun too. But today we're talking about IRAs and trusts. So Andy, in 2020, there was a legislation that came out called the Secure Act, and that made a lot of changes to, this process of using trusts as beneficiaries for IRAs. So let's first talk about that and what, really how the Secure Act affected trusts as IRAs, and then maybe some of the issues that are arisen and when it still makes sense. So I'll let you launch off from there.
Okay. Yeah. Well, thanks for having me on. I appreciate it.
Sure.
I take phone calls all day long and emails and from advisors as part of the Ed Slott group all the time, and we run into this trusts as IRA beneficiary issue all the time. It certainly makes sense in some situations, and we'll talk about that. But yeah, as far as the Secure Act, that changed everything for beneficiaries. It used to be back in the day, prior to 2020, that if a person inherited an IRA, then anybody could do what we call that take stretch RMDs, annual RMDs over your own single life expectancy. And it didn't matter who you were or what your relationship was to the IRA owner, you could do that. The Secure Act totally changed that by adding the 10-year rule for a lot of beneficiaries. Some can still qualify to do that stretch, but the 10-year rule applies to a lot of people where you have to empty the account within 10 years. By doing that, it has significantly impacted what happens with trusts as IRA beneficiaries and how that works. So that's really the foundational reason for why trusts don't always make sense for being an IRA beneficiary. But yeah, we can get into the weeds on that. I have some examples that I run into. I don't know where you wanted to take that.
Yeah, well, let's first say that if you have questions, I didn't mention this from the kickoff here, but if you're listening, if you have questions, you can put the questions in the chat bar, and we'll answer them if we have time as we go. But let's just talk about the benefit maybe of having a trust as your beneficiary, and then what some of the rules, why the rules have changed that, and why it may not be as beneficial as it was before. Because Andy and I were talking, before we started here, but I talk all the time about it. It was a very common strategy prior to 2020, and many, many people have taken the time and expense of developing trust as beneficiaries for your IRA and your estate plan. And the reasons you had prior to 2020 might be completely gone now. So it's important for you to know, what really happened and, um, what the changes have been.
Mhm. Yeah, so trust as an IRA beneficiary absolutely makes sense in some situations. It could be a special needs situation. Yes, name the trust as the IRA beneficiary to handle those dollars. Maybe a minor, you want to give the money to a minor. Absolutely. Maybe it's a person that can't handle money, immature about money, whatever it may be. But there are definitively good reasons to name a trust as your IRA beneficiary. Absolutely. Where I get frustrated is it's a whole keeping up with the Joneses thing. Well, my neighbor has a trust as their beneficiary. I want to have a trust as my beneficiary. It might not make sense. And if you put a trust as your RA beneficiary, it could just completely muddy the waters and frustrate the beneficiaries and get in the way if it's not necessary. So, uh, but absolutely, I am not saying never do it, but only do it if there's a reasonable and justifiable purpose for naming that trust as the IRA beneficiary. Absolutely.
And when does it make sense, do you think?
When doesn't it? Or
When does it make sense?
does it? Well, like I said, if it's a special needs situation, that would be good. Minor as a beneficiary, so, a bunch of situations like that. Control, a lot of times if you want to control, we say control from the grave. If I own an IRA account and I want to dictate how these dollars are allocated or used after I'm gone, I can put a trust in place to do that. So definitely there's times to do it. Um, if you just want to, if I'm not worried about control, if I don't want to control these assets after I die, if I just want to give them my IRA assets to a mature, responsible adult, whether that may be my adult child or whether that may be my spouse, then just name those people directly. Because if you don't, and you name a trust, then the trust is the beneficiary. And we have a whole process of setting up a trust owned inherited IRA. The trust rules are going to dictate what that person can or cannot do. And like I said, it's an impediment oftentimes to these people that you just want to give the money to, but now this trust is a buffer and it's in the way, and it could certainly cause more problems than what are necessary.
Yeah, and just for clarification, folks, we're talking specifically about naming a trust as an IRA beneficiary, and we're going to talk in a bit about what complications that causes, and when you're talking about required minimum distributions and distributions from these IRAs, um, where, there are many good reasons potentially to even within an IRA to name a trust as a beneficiary, but outside of an IRA for sure, like all the reasons Andy's talking about, control, special needs, um, spendthrift issues. You're afraid somebody's
Mm.
going to spend through their money too quickly, but there's a level of complexity. So it's relatively simple. I'm not going to say easy, but it's relatively simple. If you say, okay, I have non-IRA dollars and I wanted to go to my grandchildren, for example, and here's how I'd like it. Here's how I'd like it paid out when we're no longer here. Um, but that's relatively simple. When you add
Yep.
on IRA rules, this is where it gets complex. So let's talk a little bit now. Now remember, folks, we're talking about you've got IRAs, traditional IRAs, or I guess even Roth IRAs, right? You know that's a whole other thing. But you've got IRAs, and now instead of naming a direct beneficiary like Andy was talking about, instead of saying, child 1, 2, 3, or whomever your named beneficiaries are going to be, you say, I'm going to put an intermediary in there, which is really what the trust is. Put an intermediary in there. And now the trust is going to receive the IRA assets and it's going to be paid out to the beneficiaries the way I say it's paid out, except for you're also colliding with the rules around the distributions. So let's talk a little bit about those payout rules when a trust is an IRA beneficiary, Andy.
So everything you said is 100% on, and I like this right here. We talk about that, how the IRA rules butt up against the trust rules. So um, typically, a trust will be a see-through trust or a look-through trust, where you can look through the trust to see who the trust beneficiaries are. So, if I name my adult child, I would look through the trust. I would see that my adult child is the trust beneficiary. And then I would set up if when I die, this trust owned or trust held inherited IRA, and the payout rules would be what would be applicable to that trust beneficiary. So if it's a 10-year rule, or if it's a special needs situation, let's say it's a truly a situation where you want to and you need a trust as beneficiary, you have a special needs child uh, as the beneficiary of that trust, I can look through that trust. I can see that special needs child, and then that child qualifies if that child is truly special needs and disabled, qualifies as what we call an EDB or an eligible designated beneficiary and can get a full lifetime stretch. So I set up this trust-owned inherited IRA. The monies stay in a qualified status. I use that child's age to determine the annual RMD payments, and then those payments will ultimately each year pay out of that trust-owned inherited IRA into the trust account. At that point, they can be used how the trust dictates. So that's a perfect rule of how it would work. But it's not always a stretch situation. It's not always a situation where you need to have a trust owned. So I'll give you an example. So here's where things changed in 2020. And whenever I present this, I always use this example because I think this is what really sets the stage for people saying, yes, I need to make sure that I review my trust if I have one in place. So here's my example. So let's say it's pre-Secure Act. So we're talking 2018, 2019, what have you. We have a father, he's in his mid 60s, and his son is probably like 25 years old. This son has a gambling problem. So just like you said, a spendthrift. So he cannot trust this son of his to handle these IRA dollars. Let's say this gentleman's wife passed away, predeceased him, or maybe he's divorced. So his only beneficiary is this son. He has $1 million IRA. So prior to the Secure Act, he names this trust as the beneficiary of his IRA. That was perfect back in the day because what would happen is the trust would say, we're only going to pay out the RMD to this kid. So if dad were to have died in 2018 or 19, we had this trust-owned inherited IRA. We look through that trust. We see that gambling addicted kid, but we can use his age to pay out annual RMDs. Everything's great. If dad dies, trust owner inherited IRA, that trust is the buffer. The kid cannot invade the IRA and take the whole thing. The trust says just pay out RMDs, all is well. Here's where things have changed drastically. That trust was in place. Everything was perfect in 2018, 2019. Now we have the Secure Act. The Secure Act adds this 10-year rule that we're talking about. Let's say now it's 2022, 2023, 2024. Dad is mid to late 60s and he dies. He hasn't reviewed his trust, hasn't changed anything. So the exact same trust is in place that says pay out RMDs. But the rules have changed. So now that exact same trust is in place. Dad dies. We look through the trust. We see that child, that adult child, 25, 26, 27-year-old. He now gets the 10-year rule. There's no stretch for him because of the new rules. So the trust does exactly what it's supposed to do. We set up a trust-owned inherited IRA. We look through, we see this kid. We set up the 10-year payout rule. There's no annual RMDs because dad died before he started taking RMDs. So we have no RMDs in the 10-year rule. So what does the trust do? It just sits there. This trust-owned inherited IRA doesn't pay out anything in years 1 through 9 because it's supposed to pay out RMDs. At the end of year 10, that final payment is technically the final RMD. So the entire IRA is paid out in one lump sum to this kid. Completely changes what was the intent. He skips off to Vegas, burns through the account, and dad is rolling in his grave because he didn't review his trust. So that really summarizes exactly how drastically things have changed with the Secure Act.
Yeah. So I wrote some questions down, and we have a question from Paul. So
Okay.
let me first ask this question. So you talked about the see-through, and you described it really, really well, right? You got to have a name beneficiary. You have to be able to kind of see that person. What about no name trust beneficiary, like a general naming of children or grandchildren? You know, what we commonly see as issues, right? So what if, is that considered a see-through? Is that clear enough?
Not necessarily. So there's a couple of things you have to do to qualify as a see-through. Like the beneficiaries have to be identifiable. So you can't just say my friends. Um, and it has to be a legal document. You have to provide that document to the custodian by a certain date. So some basic things. If you fail that look-through rules, then you wouldn't use that kid's age. Then you might get stuck with, depending on how old the person was when they died, you might get stuck with the 5-year payout rule or the ghost rule that we talk about, where you would use the deceased person's single life expectancy. So a couple of variables come into play as far as how that trust is designed. Usually they're done well and we can look through it, but you're absolutely right. If the trust is not designed properly, you could face an even shorter payout rule than even the 10-year.
Yeah, and you said an important point there. It's going to be evaluated by the custodian. So when we're talking about custodian, we're talking about, Charles Schwab, Fidelity, Vanguard, so if it's not clear, it's open to interpretation. So that's always the concern because listen, sometimes, let's be honest, you get the back office person who's on their toes and knows really what they're talking about, and then you get the other person that has a lot of stuff on their desk, and they're going to have to research this a little bit more, and they just send it back, or say, that has to be done this way. So you said a couple important things there, and Paul, we'll come to your question, I promise. But you said you may have to use the 5-year rule or the ghost rule. I think we should talk about that a little bit. What do you mean by that?
So we see this mostly with estates when an estate is a beneficiary. Because like I said, a trust is oftentimes designed as a see-through, so you can look through and see the trust beneficiaries and use those folks. But an estate is what I call a non-person. So a non-person beneficiary. When you have a non-person beneficiary, and that could be a trust if it doesn't pass the rules, then you have two payout options. And it's all predicated on when the IRA owner died. So if they died um, prior to the required beginning date when RMDs were turned on, or if they died after the required beginning date. So if a person dies prior to what I say turning RMDs on lifetime, like when they're 73 and RMDs have to start, if they die before that and you have a non-person beneficiary like an estate or a trust that doesn't pass the look-through rules, then you have the 5-year rule. If you die after the required beginning date, so a person is 74, 75, they turned on required minimum distributions, then you have the ghost rule. So the ghost rule would be you use the deceased person's age in their year of death, find out what that age is, single life expectancy, and -1 off of that each year thereafter. So that's why we call it the ghost rule. We're using the single life expectancy of a deceased person to determine future required minimum distributions off of an account.
Okay, thank you for that explanation.
Yep,
Paul Paul
it's a
asks,
crazy.
I know, there's so many. Well, that's and it's people who listen to this all the time are always. I think you know this, but the first 15 minutes or so, I read the slot reports. I share them on the screen. I read
Okay.
them because there's so much good information in there, and
That's what
the
we write too, by the way.
yeah,
Hopefully you read some of mine. That's what
oh,
I,
many times,
every,
many times.
yeah.
And I remember I was when we were in National Harbor. I had dinner. We were having dinner with Ed, and I told him, I said, my first 15 minutes I spend reading the mailbag and the slot report, and he loved that. So it's fully endorsed by Ed Slott to share that material.
Sure.
But Paul
Sure.
Paul writes, what about the trust as option to get the money out of the estate? Good question, Paul.
Yeah, it all depends how you want to do that. I would defer to the estate planning attorney, to the tax folks of how that's going to work. That's really more up their alley. What we're talking about is the payout rules, the taxability of those dollars that pay into that estate, and how that can be a worse situation. I know some people think they can get some kind of tax benefit with having a estate. Taxes could actually be worse if you name a trust as your beneficiary. But as far as uh, uh, those assets remaining in the estate or not, it's going to be a trust-owned inherited IRA if you name that trust. So it will belong to the trust, whether or not that's part of the estate. It's not paid into the estate yet, but how that's handled as far as the overall estate. Uh, Again, I would defer to the CPA or an estate planning attorney there.
Yeah, and the only way that you would be able to get a trust excuse me, an IRA out of your estate, whether it's via a trust or not, would be to to take it out of the IRA, right?
Yeah, pay
So
it out.
yeah, and that would be a full taxable event.
Well, that's a danger is people think, well, I am alive. I have this IRA. I want to put it into my trust now while I'm alive.
Yeah.
And that is a no-go zone. That is a full distribution. A trust while you're alive cannot be the owner of that IRA. It's got to be an individual. It's got to be a person. So we've seen situations where people have done that full distribution. Attorney has been sued, taxes have been owed. It's been very sloppy. So while alive, definitely can't put money into a trust while you're alive, an IRA.
Yeah, and we were talking in the prior to launching the webinar today. Um, and Paul has a Paul has a follow-up question. Okay,
Keep them
so
coming, Paul.
what if it's already converted to a Roth IRA?
That's a good question. A Roth IRA, and that's actually a good segue. So, Paul, good question. Thank you for that. A Roth IRA actually makes a much better funding source if you're going to name a trust. So here's why. Let's go back and just say let's say it's a legitimate need to have a trust as your IRA beneficiary for whatever reason, special needs, etc. Let's say we have a traditional IRA. So the person dies, they name the trust as the IRA beneficiary. Great. We open up a trust owned or trust held inherited IRA. Those dollars still remain in a tax deferred status. When they are paid out, whether it be an RMD or whether it be the trustee of the trust electing to take a distribution, when those dollars pay from that trust owned inherited IRA into the trust, now we have to consider the taxes that might be due. Typically, if it's a conduit trust, those dollars are then paid out from the trust to the trust beneficiary and will be taxable to the trust beneficiary at whatever their personal tax bracket is. If, however, it's, let's say, an accumulation trust where money pays from the trust-owned inherited IRA into the trust and those dollars sit in the trust, now we have to worry about the high trust tax rates. And when I say high trust tax rates, for 2025, I think I've got it written down here, 15,650. So trusts hit the highest bracket, the 37% bracket, at only $15,650 of income. Opposed to that, if a couple was married filing joint, they don't hit the 37% bracket until over $751,000 of income. So when money pays into a trust, the high trust tax rates apply unless those dollars are paid out to the trust beneficiary. So getting back to the question about a Roth, if I've got a Roth IRA, if I had this traditional IRA and I converted the whole thing to a Roth, and I'm still going to name that trust, that's fantastic because it eliminates that concern of the high trust tax rates. It will be a tax redistribution. So we don't care about the high trust tax rates. And if those dollars are then subsequently paid out to the trustees, or excuse me, to the beneficiaries of the trust, then they would not have to pay taxes on those dollars either. So certainly a Roth IRA makes a better funding source than the trust. And we say, if you know that you have a legitimate need to name a trust and you have a traditional IRA, while alive, it might be wise to engage in some sort of annual partial conversion strategy to get that money moved over into a Roth.
Yeah, that's a good point. There's a couple things I think to consider with that though, as I'm thinking through it. So first of all, it's definitely is more tax efficient. Andy's right. I was pulling up the 2025 tax planning chart to share with you all, but he explained it very, very well.
I stole your thunder. Sorry.
No, you're fine. No, it's good. And everybody knows they can download that from our website anyway. So, the, but so any distributions are going to be tax free and they shouldn't accumulate in the trust. Andy's right, because it's going to be taxed, but any distributions to the trust beneficiaries are going to be tax free, but we still have the 10-year issue, right? So
That's exactly right.
we still have the 10-year rule. So if it's a because there are no RMDs. Andy had talked about, well, if somebody dies before their RMD age, actually their required beginning date, then there's this rule for RMDs. There are no RMDs. If they die after the required beginning date, well, there are RMDs. But Roth IRAs are deemed never to have RMDs, right? So
Exactly.
that has to be liquid. You basically have one required minimum distribution, and that's the 10th year after the year of passing. So
That's
if
right.
you,
That's right.
yep,
Because there's no RMDs while
that's
alive,
right.
you could be 100 years old with a Roth. You're deemed to have died
That's right.
for the required beginning date. That's exactly right.
So, but that if your reason, go back to the reason for setting up your trust. If your
Mhm.
reason is, I don't want my child to, my child has a great gambling problem or drug problem or just doesn't do well with money, and I don't want him or her to blow through this, $3
Yep.
million. They're still going to get all of it at once at the end of that 10th year, because that's that conflict of the trust rules or the trust provisions compared to the IRA rules, because your trust could say, well, I want it paid out for over his lifetime over this, we're going to put a Roth in there. It's going to be paid out over their lifetime. But if it's still an inherited Roth IRA inside that trust, then that's going to be paid out all at once.
And I will say there is excuse me, there is a way to somehow soften the blow, but you're still going to get drilled with taxes. So let's say it is not a conduit trust, it's an accumulation trust, because this trust knows that, let's say it was set to pay out RMDs, but this trust knows that this kid can't even handle RMDs, so also only wants to pay him out $100 a year or something like that.
Mhm.
You could have language in the trust that says don't pay out anything. The distributions from the trust to that person are totally based on what the trustee decides.
Mhm.
So yes, at the end of 10 years, that entire IRA, maybe it's a traditional or maybe it's a Roth, will dump into the trust. At that point, if it's a conduit trust, yes, it's going to get sent right out to the beneficiary. But if it's not, if it's an accumulation trust, those dollars can sit in that trust and be paid out as the trustee decides. However, they're going to get drilled that 37% if it's a
Yeah.
traditional IRA.
Yeah. And if you got $1 million, $2 million, $3 million, $5 million in a trust, it's not hard to get those numbers.
Yeah,
There's income. We're talking about income that's generated from the amount in there. Alternatively, you could do a full distribution. It's no longer a Roth IRA that's not taxable. It can go into the trust as the net dollars in there, and then it could be distributed out per the trust, but it's no longer a Roth IRA. There's no more
that's right.
tax-free accumulation. So I know we're bantering around a lot, and this just goes to show you it deserves a conversation. If your trust is more than 5 years old, here we are, right? It's 2025. This was 2020. You should review it thoroughly. You all know my thought. You have a financial plan. You should review your financial plan every single year. That should be part of it. If you had a trust as beneficiary, and you should have been hearing this, frankly, from your qualified financial planner, financial advisor. But if you're not, jump on it now. And if you have questions, I can't do it here through Zoom, but you can reach us at questions@attleborowealth.com. That's questions at Attleboro, ATTLEBORO wealth.com. The guy, so Paul, just going back to Paul's question. So Paul is his his original question had to do with the estate, and whether it's a traditional IRA or Roth IRA, you're the estate calculation is the estate calculation is the same, right? So you can't. There's no effective way that I know of. If somebody knows, please tell me. There's no effective way to gift IRA assets, during your lifetime, other than qualified charitable distributions, right?
That's right.
In
QCDs you can
general.
do if you're 70 and a half.
Yeah,
You can't gift an IRA and keep it as an IRA. If you want to take a
you can't.
distribution from
Right.
the IRA and then
That's
go
right.
ahead and give that to those dollars, you certainly can.
That's right.
I mean, I've heard some crazy stuff that I don't want to mention about people trying to move IRAs to spouses and stuff like that. But we don't
Yeah.
believe any of that stuff is legal.
No. And let's go back to that for a second, because you talked about attorneys getting sued, and I should just I did a webinar last year about a CPA who gave a client really bad advice, and I had a comment on it, and but we were just talking. We recently had an attorney for a client who wrote in an email, I set up this trust to circumvent the 10-year rule under the Secure Act, and I read that a couple times, and I thought to myself, there's no way to circumvent the 10-year rule that I know of for a non-eligible designated beneficiary. And we should talk, Andy, about what eligible designated beneficiaries are. But I captured that sentence and sent it to Sarah, who you all heard just a few weeks ago, and said, Sarah, I'm seeing this from this attorney. Do you know of any way to circumvent the 10-year rule using a trust? And she said, I'm just as confused as you are, Mark. So that unfortunately, this person's attorney is giving them bad information that they may not realize until they're no longer here, and it didn't do what they wanted to do. So we're working on that. But that's just an example. Because somebody has ESQ after their name, or CPA or CFP, or it doesn't mean that they're staying up on these things. This has now been 5 years, so it's almost not forgivable to know, not know what the rules are here. But um, there's a lot of financial advisors, financial planners in the country, and there's only what, 400 and how many now in our group?
Yeah, about 500, about just about
That's
maybe
great.
about 500. But I but
That's
I
great.
I see it all the time. Yeah, Sarah's fantastic. I talk to her every day, and she's good at reviewing trusts. I know a lot of our advisors will have trusts. They'll send her trusts that she can look at. And I would say of the trusts that she's reviewed post Secure Act to see if they still work, 98% of them do not.
Yeah.
So out of all the trusts she's reviewed, every single one of them essentially has had to be redone. So if you have a trust that was put in place prior to the Secure Act, it has got to be reviewed. And you're right, it's been 5 years, so it's pretty much inexcusable.
Mhm.
But people still don't know what's going on. Somehow it's escaped a lot of folks. People are getting better. I'll certainly give people credit, but it still slips through the cracks in some areas.
Yeah, and it's not the client's fault. We
Not at
don't
all.
expect clients to stay up on these things. We do these webinars for education, and I talk about that all the time. You should not be taking advice from anybody, including me, producing webinars. This should be education. Advice should be very specific, very individualized and specific. That's where advice comes in. But pay attention to the education. Share this webinar with people who are close to you, because a good attorney a good attorney will know about these updates, right? And when a trust that they drafted it back in 2020 doesn't make sense anymore, and that attorney will be reaching out to you. But I got to tell you, most attorneys are reactionary, not to degrade the profession, but you don't hear from them unless you call them with an issue, right? And it's just like most CPAs driving the rearview mirror. They reconcile what you did the prior year and maybe a little bit of planning as far as you should make a contribution to an IRA, and hardly ever Roth IRA. But uh, it's hard to find the professionals that are more forward looking and stay on top of things. We have
I
another
will
question.
say that, and I agree with that. It's not, and I don't blame the client at all. It's 100% the professional involved. But I
Yeah,
did have an
absolutely.
advisor, a member advisor with that Select Group last week who called, and he wasn't looking out the rearview mirror. He was looking forward and doing some
Good.
forward-looking planning. And he had a situation where a person had named a trust as the IRA beneficiary, and we talked about it. I said, is there a need for this? Is it special needs? And there was none. It was just simply that the husband wanted to transfer the assets to his wife and to his children, and he had some charities involved as well. And the attorney said, just name the trust as beneficiary for everything. After our conversation, he went into that meeting the next day, had a good conversation, and they changed their beneficiary form. They named the wife directly. They named the children directly. All the other assets that they had, non-IRA, they still kept the trust, and that's fine. The attorney knows better than I about that. But when it comes to the IRA, it didn't make sense to name the trust, so they simply changed the beneficiary form.
Yeah, which is the easiest thing to do. And you
Mhm.
can you can change the beneficiary form much easier. And you should review those every year too. Nobody's being
Absolutely.
surprised in here. Okay, so we have another question. So Don writes, I have generated 5 trusts, one for each of my daughters, 4 grandchildren, to use their individual social security numbers. Wouldn't this cover the 37% issue when the trust inherits the traditional IRA?
Okay, so when the trust inherits the traditional IRA, it is still going to stay in a qualified status. So those dollars will still stay tax deferred. It'll be an inherited IRA that is owned by the trust. It sounds like in this situation, you may have named 5 different trusts for the IRA. So the account would be split up. The IRA would be split into let's say 5 different inherited IRAs, each owned by those different trusts, those 5 different trusts that you've identified or created. So that's fine. We're good to go so far. depending on who those beneficiaries are, you say it's a grandchild. So I don't know who the trust, the beneficiary of the
Daughter and
trust is.
4 grandchildren.
Daughter and 4 grandkids. Okay. So the daughter, if there's a daughter and 4 grandkids, the daughter would, if she's not disabled or wouldn't qualify to get the stretch, is going to get the 10-year rule. So let's just look at that one. So we have your IRA, you name a trust for daughter. Uh, she gets her, we have an inherited IRA that's owned by her trust. We look through that trust, we see daughter. Daughter gets the 10-year rule. I don't know if Don is over or under RMD age. Let's say hypothetically he is 75 and taking lifetime RMDs from his account. The trust owned inherited IRA for daughter would look through, see her age, see that she gets the 10-year rule. We would have annual RMDs from that account for years 1 through 9 because Don has turned RMDs on, so to speak. Those RMDs would be based on daughter's single life expectancy. Those payments would go from that trust owned inherited IRA into that trust that you created for her. If those RMDs stay in that trust, 37% tax bracket.
Correct. Yeah.
If they are subsequently paid out to daughter, taxable at her tax rate. So the trust doesn't, having that trust certainly doesn't help save taxes. It could exacerbate
Right.
the situation if those monies stay in the account. Hopefully it would be a conduit trust and they would simply pay out to daughter and be taxed at a lower rate. And
Yeah.
the same would apply to the grandkids as well, as far as what their payouts would be.
Right. And Don just posted he's 71, his wife is 76. So
Okay, so that's perfect. So if Don's 71, then we would still have the 10-year rule. Daughter would not have RMDs in years 1 through 9. So same thing. She could, however that trust dictates, the trustee would pay the money out. Same thing would happen though. Any money they paid out would, if it was paid to the daughter, would be taxable at her bracket. But no RMDs in years 1 through 9 because Don hasn't turned RMDs on yet.
So what Andy just said is important. So there wouldn't be any RMDs because Don's prior to, and this is a really good example. So Don is 71, so prior to required beginning date. His wife is 76 after required beginning date. So you have two different things happening there. So
Yeah,
if the what now if Don passes and the kids grandkids inherit, no RMDs, right?
that's right.
If wife passes, RMDs because she's over the
Yeah,
required
if
beginning
wife
date.
had the exact same thing set up because
Yeah,
she is taking lifetime required
yeah,
or minimum distributions, absolutely. The 10-year rule, since RMDs were turned on, we can't turn them off. So they would apply in years 1 through 9 to daughter and to the grandkids. And just so you know, just to be clear here, grandkids would also have the 10-year rule. Even though they're minors, if they're younger, they don't qualify. I know, Mark, you said you wanted to talk about the different beneficiaries. Grandkids don't
yeah,
qualify as an
yeah.
eligible designated beneficiary and wouldn't be able to get that stretch. They get the
That's
10-year
right.
rule as well.
They get a 10-year rule. Yeah, and yeah, there was another point I wanted to make, but it's interesting to lay another layer on this. However, if wife dies first and Don is the beneficiary and then he dies, then there are no RMDs.
That's true. God forbid.
Depending on wait a minute, depending
God
on how
forbid.
Don treats the inherited IRA, right?
Well, this is a good example. So let's say that Don and wife, they want to give their IRAs to each other. They simply want to give those IRAs to each other. If Don were to name his wife or wife were to name Don as the direct beneficiary on the account, not the trust, just wife names Don.
Mhm.
Sadly, wife passes away. Don, as the beneficiary, can do a spousal rollover. He can
Mhm.
simply take her IRA and move it into his name. She
Mhm.
was taking RMDs at the time, but once he puts it into his name and his account, those turn off because it's now deemed to be his dollars from the get-go. It's like it was always his IRA. If wife names a spouse, excuse me, names a trust as the beneficiary, and let's say Don is the beneficiary of that trust, Don can't do a spousal rollover. The trust is in
Great
the
point.
way. We have to look at what the trust rules say, what the payout rules are, what's the language in that trust. Now, we've seen a number of private letter rulings to the IRS, PLRs, where a spouse named a trust as beneficiary. The surviving spouse was the sole beneficiary of that trust, had total control of the assets, and the IRS allowed a spousal rollover. But it's this extra step, it's this unnecessary hurdle. Just name the spouse directly. If I don't want to control the assets and I want my spouse to get my money, name the spouse directly. Don't put that trust in the way because it's only going to cause road bumps, speed bumps.
Yeah, that's interesting. I remember that from the updates last year. Is that it's relatively recent, the allowance, isn't it, of the spouse
It's
to,
been it's
yeah,
been going. There's been a number of PLRs over the years. Now you don't need a private letter ruling. A lot of
nice.
times custodians will just allow it. But if the
Yeah,
custodian says no deal, we're basically leaving it in the hands of the custodian, the Fidelities, the Schwabs, whatever, to say, okay, we will allow you to do this spousal rollover. If they
yeah,
say no, then you might be forced to get your own private letter ruling, and we're talking thousands of dollars to get
yeah.
one of those things.
What's the average now for a private letter ruling? Is it
I think
10,
it's 12,000. I think it's
12,
12,500 or
12,000?
something like that for a
Yeah,
private
that's
letter
good.
ruling for something like this. For a situation like this, it's upwards of that. And of
That's
course,
good.
you have all the administrative fees, the filing fees, et cetera. Not worth it. Just name the spouse directly, and they can get those dollars. I would say the same thing. We talked about these five different trusts for the daughter and the four grandkids. For the daughter, if she is a healthy, mature adult and there's no desire for Don to control those assets for her one-fifth portion after he dies, just name her directly. That way she can set up her own inherited IRA. She can do with it whatever she wants to do without worrying about the trust. If the four grandkids are minors, then yeah, go ahead. Name that trust as the beneficiary. Now the trustee can control and dictate how those dollars are paid out.
Hmm. Yeah, manifold. Lots going on. All right, Don. I think we've answered. Yeah, I think we've got that covered. Good. All right, so let's talk about eligible designated beneficiaries, non-eligible designated beneficiaries, and everything that falls out of there. And these are all new since the Secure Act too. And I guess the Secure 2.0 didn't redefine any of those definitions, did it?
It
But
didn't redefine them. It clarified a couple of things. Um, Secure Act is the one that really threw the monkey wrench into everything. It used to be prior to the Secure Act that anybody, as I mentioned earlier, anybody,
Mhm.
any living person, if they inherited an IRA, could use their own single life expectancy and set up annual required minimum distributions. These could go out, depending on how old that person was, 60 years.
Mhm.
Um, Basically, the purpose of changing these beneficiaries was to speed up that process. If I inherited an IRA back in the day, it might take decades for me to take distributions out of that account, which means that money stays in a tax deferred status. What the 10-year rule does for most beneficiaries now has certainly sped up that payout process, which means tax dollars get paid in a heck of a lot more quicker. But there are still people that qualify for that full lifetime stretch. Those are the eligible designated beneficiaries. So, spouse is an eligible designated beneficiary. And I don't even want to count spouse because a spouse is almost like a super beneficiary. A spouse has a bunch of
Mhm.
different rules that they can do, like the spousal rollover that we talked about. But as
Mhm.
far as non-spouse beneficiaries, um, minor children of the account owner. So I said grandchildren don't count. It has to be a minor child of the account owner. So grandkids aren't going to fit in that situation. Disabled people, chronically ill people qualify as an EDB, eligible designated beneficiary. And then there's one sneaky category. It's people that are not more than 10 years younger than the IRA owner. And that could
Mhm.
be anybody. So basically, if a person is 50 years old, anybody in the world that is 40 years old or older could qualify as an EDB. Again,
Yeah.
it's anybody not more than 10 years younger than the IRA owner.
Yeah, and that could be your older brother or sister.
Older, yeah,
Yeah,
older
it's
also
yeah,
counts.
yeah,
It could
yeah.
be your
It's
neighbor. It could
yeah,
be no family relationship necessary. So
yeah,
anybody who is older, but
true.
it's just that 10 years minus your age, and then anybody above that can qualify. If you can't fit into one of those categories, chronically ill, disabled, not more than 10 years, et cetera, then you are an NEDB, a non-eligible designated beneficiary. So that's basically everybody else. Um, those folks get the 10-year rule. And again, that 10-year rule, whether there are RMDs in years 1 through 9 or not, is predicated on how old the person was, the original IRA owner. If they were taking RMDs while alive, can't turn them off, they apply in years 1 through 9 of that 10-year rule.
Can you talk a little bit about the definitions of disability and chronically ill?
Chronically ill, there it's like the 9 levels of daily activity of daily living. So that's a definition of chronically ill. Disabled, if you qualify for Social Security, the Social Security definition of disability, then you meet it. It's a high hurdle. Just because a person may be retired on disability doesn't mean they are disabled for IRA purposes. Doesn't mean they're disabled for IRA beneficiary purposes. So it's got to be a significant disability to qualify as one of these eligible designated beneficiaries.
Yeah. Great. Let's see, Andy, do you want to, I know we talked about a little bit of horror stories, but what other horror stories have you heard from people who have not reviewed their trusts after the Secure Act?
There was a case that we have in one of our manuals where it, a mom left her IRA to a trust. The beneficiaries of that trust were the children, three adult children. 3 adult children had total control of the account. The children wanted to buy stocks in this trust-owned inherited IRA. But the account that it was in wouldn't allow stock trading.
Mm.
So they moved the money, took a distribution and moved it over into another account where they could trade stocks. But then they realized that was a distribution from the account.
Oh.
So they couldn't put it back, total taxable distribution. That's not necessarily a trust issue, but the fact that it was all in one trust-owned inherited account, when they took the whole thing and moved it over, it was a complete distribution of that account. Had those kids all had their own inherited IRAs, maybe they wouldn't have done a full distribution of that single account. Maybe one of them might have made that mistake, but a non-spouse beneficiary can't do a rollover. They can't put the money back. So they got nailed on that one. We've seen court cases where a person all they wanted to do was just do a spousal rollover. All they wanted to do was have inherited IRAs set up for the children. All they wanted to do was a simple transfer of money to next of kin. But again, the trust got in the way. We've seen situations where a person just wanted to do a spousal rollover, wanted to give the money to their spouse. They named the trust as the beneficiary of that IRA, but the trust had language in it which somewhat limited the spouse's control of those dollars. It was like health,
Mm.
education, maintenance, and support, those HEMS
Hmm.
words that we talk about. Since there was some limitations as far as what the spouse could or could not take those dollars out of the account for, the spousal rollover was denied.
Wow.
So again, the trust got in the way. We say it all the time. Unless there is a legitimate reason to name that trust, and my attorney told me to do it, is not a good enough reason. Unless there's a legitimate reason to do it, like I said,
Yeah.
special needs, etc. Um, do not name a trust as your IRA beneficiary. Works sometimes, but not every time. Just like you
Yeah.
said, just keep this in mind. The IRA rules and the trust rules, you're going to face this if you don't do it right.
Yeah. Yeah. This is really great stuff. All right. We've got a few minutes left. Anything else you'd like to go over, talk about?
Well, we've hit a bunch of things. I'm trying to think. We talked about taxes. Certainly, there's no
Mhm.
tax break that you can get with a trust that you can't get otherwise, and it certainly can be worse. Absolutely. Recognize the difference between a conduit trust and accumulation trust. I know people ask, well, if how do I? Here's another thing that comes up. If you name a trust as your IRA beneficiary, now you have to do the trust has to file a tax return for that
Yeah.
account. So
Yeah.
now if you do pay money out to the beneficiary of that trust, now you do a K-1 to transfer the taxes to that person. So that might be an extra step involved.
Mhm.
Um, Recognize that the beneficiaries of that trust, we would use their ages to dictate, and their status to dictate if it's a payout over annual RMDs or the 10-year rule. If it hasn't been reviewed, it has got to be reviewed. So all these different things come into play, and it's the tentacles of naming a trust as your IRA beneficiary covers so many things, like we talked about. Who's the type of beneficiary? The type of trust? Is it a see-through? Is it an accumulation? All that kind of stuff has to be taken into consideration. And again, IRAs only. We're not concerned about the other accounts because they're different. But
Right.
IRAs, for sure, it has to be reviewed.
Yeah, it's those unintended consequences that you see
Hmm.
when it all sounds good until you really dig into it and start seeing, well, this is going to limit this, this is going to require this, and it may not be what you want.
Yeah, and a
Um,
Roth is the way to go. We talked about that earlier. Certainly a
yeah.
Roth IRA. If you're gonna if you need a trust and you want a better funding source, a Roth IRA. I know Ed talks a lot about if you're insurable. I mean, an even better funding source for a trust is like life insurance.
Oh, yeah.
I'm no life insurance expert, but I know one of the strategies that people like to employ is um, maybe taking some withdrawals from your IRA and use that to buy like whole life and then name the trust as the beneficiary of that life insurance. So now you're going to get a full tax-free payout to the trust, as opposed to this traditional IRA, which is laden with taxes that's going to pay into that trust account. So again,
Yeah.
forward-looking planning, which I'm sure Mark you help people with.
Yeah. That's something I learned from Ed. And I talk about these aha moments, and mine was in, I guess, 2012 when I attended my first 2 day. I guess that's right. 2011, 2012 or something like that. But I talk about, I'm a newly minted CFP. I was feeling really confident over 10 years in the business at that point. And I just sat in the back of the room there and I thought, oh my gosh, I've been missing so much. So it was very humbling. And
Yeah.
that's when I got involved with the group. But Ed writes, it's on my website. I'll just read it to you. As a tax advisor, I have to constantly remind people the single biggest benefit in the tax code is the tax exemption for life insurance. There is no question that that's the way to keep most of your money, if not all of it, protected from taxes forever. And that's such a strong statement. But Ed's got a lot of those. But that it's really really clear. It's really simple. Talk about simplicity, right? You've got a death benefit. It's tax free. Period. It can still be counted in your estate, and sometimes it makes sense to put that in a trust, put a life insurance in a trust, right? But and there are questions for the estate plan to be worked through, but boy, uh, it's relatively simple. Now that is not easy because not everybody qualifies for life insurance. That's the problem with
Right.
it. But if you qualify and it works for you, boy, it can work really, really well. I'm glad you
Yeah,
brought
as
that
I was
up.
saying, if you're insurable.
Yeah, if you're insurable, yeah.
Yeah. So
Um,
yeah, there's so many things to cover. I just know that now people don't call me when everything's going smoothly. So I will say, I will put an asterisk on this that says that I get the calls when things get sideways. So I unfortunately have to wade through a lot of the garbage when it comes to, when it comes to trust and problems like that. So keep that in mind. I might be a little bit biased when it comes to trust as
well,
IRA beneficiaries, but at the end of the
the
day, I
thing
know that
is, the thing is, it's not correctable, right? So it's important. I think sometimes you really have to look at things with a critical eye because if you don't, then somebody ends up like once you're dead, first of all, right? There's no correcting that. And you talked about the distribution. Somebody took a distribution out of the trust. And that's an IRA. We're talking about IRAs, right? So it's inherited IRA inside the trust, and that's distributed because the trust language, it's not even talking about RMDs and things like that. The trust language says you can't invest in these things that you want to invest in. And they're the rules. You have to follow those rules. And I've seen that, by the way. Well, now the person says, okay, I'm going to move this and put it into a different account. And oh, by the way, it's 100% taxable. And they may not have realized that, so realize that.
that's
And
another, yeah,
that's,
another
yeah,
layer of problems. I will
oh,
say,
another whole layer
kind
of
of,
problems.
we're talking about different situations. I wrote an article you mentioned the slot report. So I did an article a number of years ago, and admittedly, I put a title on there that was clickbait. It said, "Stop naming trusts as IRA beneficiaries," and I said that's going to get a little bit, some attention. So, and I put some real basic stuff in there, and I talked about how trust certainly makes sense in some situations. I talked about how there's no tax benefit that you can get, a couple other different things.
Mm-hmm.
That apparently hit a nerve for some people because I did have a couple of attorneys that call me and they were mad at me for saying that. They saw that clickbait and they were mad because I was maybe cutting into their business. And one attorney called me, and he said you cannot say that. You cannot write that in an article. I said, did you read the article? He said, you cannot say that. You cannot say that in an article. I said, did you read the article?
All
And
right.
he said, I said, let's read through it together. And I just hit the bullet points, and he agreed with every single one of the bullet
Yeah.
points. But unfortunately, again, I apologize for the clickbait on that article a number of years ago, but he agreed. The attorney agreed. It doesn't fit in every situation. Um, I understand that, a lot of attorneys are trying to sell trusts.
Mhm.
But just be smart. Is this completely necessary or not?
And what are the potential um,
Ramifications. Yeah.
issues? Yeah, what are the potential
Yeah.
issues that are going to come out of it? Yeah. One
Yeah.
last
Keep it
question.
simple. Keep
Sorry.
it
Yeah,
simple. No, I was
keep
going to
it
keep it
simple
simple.
as much as you can. Right.
Yeah.
Um, so there are times when it makes sense to name a trust
Yes.
as a beneficiary,
100%.
but Andy used a really good term, tentacles. You have to look at the tentacles and how it's going to affect everything. And if you don't kind of flesh those out and see, all right, well, what are the potential problems with this, or where could this cause an issue for your heirs? Then you haven't done your homework on it. Um, So Roseanne writes, "Is there one tax rate for monies in trusts?" So Andy, you can speak to it, but Roseanne, I'm good. I know you've downloaded the forms from our website before, but you can see the brackets for trusts in there. It's much smaller. There's only three, I think. Yeah, there's only three, so it's or four. Excuse me. It's 10%, 24%, 35, and
And
37.
30 cents.
But what Andy had said was, and he's correct, you trigger the 37% income tax rate of 15,650 as compared to for a married couple $751,600. The 10% runs 0 to 3,150 compared to 0 to 23,850 for a married filing joint couple. 24% is 31,151 to 11,450. 35 is 11,451 to 15,650. I'm not that smart. I'm reading it. But they're the trust marginal tax rates. And Roseanne, you can download, or anybody, you can go to our website, attleborowealth.com, go to the slot corner and scroll all the way down to the bottom, and you can download these sheets. But you can look at these and see the big difference between your marginal tax brackets, whether you're married, filing jointly, or single, compared to trusts. The and that's the difference between an accumulation or a conduit. If it's a conduit, it makes sense. That income flows right out to you. You pay it, and you on your tax return, as opposed to it staying in the trust and paying income within the trust.
And that is a key point because I hear that all the time, even from advisors. They say if they name a trust, I am going to get hit with the high trust tax rates. No, not necessarily the case. Exactly what you just said, Mark. If it's a conduit versus accumulation, those are paid out, you don't have to worry about it. But if those dollars stick in that trust after they're paid out of that inherited IRA, then yes, then those high brackets certainly can come into play.
Mhm. Mhm. Yeah. All right. Andy, this is excellent. Always great to see you. I don't think we have any other questions, but I'll just check one more time. No. So we're going to call it there. It is nearly
Okay.
11 o'clock, 10:58. Hopefully I get to see you in Atlanta. I think is that our next stop? Is that what it is? You said in May?
A lot of good stuff. Get
Yeah.
all the advisors in there and talk about more stuff. Yeah, more educational stuff.
Yeah. It's always good to see you there and spend some time with you. And I appreciate you being here today.
Thank you. I appreciate the invite. It was a good conversation and an important conversation for sure.
Yes. Yes. Thank you. And thank you everybody for joining us, and we'll see you next week. Take care. Thanks, Andy.
You're welcome.